What are the main bullet points then that we will be going through? What you'll learn: a review of a standard form TP1, transfer of part, what needs to go in it, and land registry guidance. A look at a more complex set of transfer clauses with specimen wording and layout. Plans and what can go wrong, including possible requisitions, rejections, and land registry requirements. Covenants you may need to add to the transfer, and how to make sure they run with the land. How they might be challenged later, such as Section 84, the Law of Property Act 1925, interpretation of wording, for example, what is a dwelling house, what is quiet enjoyment, easements and their protection. Building plot has to have sufficient rights to enable it to be used as a dwelling, and how are these clauses interpreted? Is it always common sense? Not always. Land registry searches of part, look at the OS2 format and how to complete it. Discharges of parts and common problems, of Land Registry Practice Guide 31. And UK Finance Handbook, what parts are relevant to dealing with part on a title. We'll move on then to plans and what can go wrong, including possible requisitions, rejections and land registry requirements. Examples of typical requisitions. First one, you have supplied a plan which shows an extent of land which does not agree with the area shown on the approved layout plan. So do check that you have based the plan or the developer's conveyancer has on the current version of the layout plan, because these plans are often subject to revision. Next potential requisition, you have supplied a plan where the area is different from the property description set out in the transfer of part. You have to double check that the property description clause takes into account all of the land to be included in the application, that the plan agrees completely, and if there are any exclusions, that these are set out unambiguously. And what about the literal or other interpretation of rights granted? In Dickinson and Casillas, Mrs. Casillas had a house which was part of a transfer of part from the next door's property, Mr. and Mrs. Dickinson. She had a right to enter on the Dickinson's property with workmen, tools and materials on that adjoining land. That's how it sounded good, for the purpose of effecting maintenance, repair and decoration. She wanted to go and have a look at her flank wall, needed access onto the neighbour's land, the Dickinson's land. They said, no, you can't come. You can only come if you come with workmen, tools and materials, because that's what the clause says in the transfer. You might say it's ridiculous. It went to the Court of Appeal at considerable cost. The Court of Appeal says this is nonsensical. How could she come with workmen, tools and materials when she doesn't even know what needs to be done yet? The right must be interpreted sensibly, that she can come and have a look first and then enter with workmen, tools and materials.